Item number 1.
You can just petition on the website.
No, that's...
Yes, Mr. Manager.
I'll not trouble your Lordship today. Lordship will take it tomorrow. Mr. Mozika's on the other side. We're trying to come to some sort of something which we can place before your Lordship. I'll just say, Lordship, what the matter is. Your Lordship had passed this order regarding determination of rent in respect of some cantonment areas and defence lands. So, only issue is, your Lordship has said the respondent authorities will hear the objection. So, I wanted only the clarification that which authority, defence, estate officer, whoever. So, I believe there is no difficulty. I'm just talking to my learned friend who's for the government. His stand is also there on the affidavit. Lordship takes it tomorrow. We may be able to come with some minor correction. Your Lordship will do that.
No, it is the military who does it.
Yes, I know. DEO.
My lord, here what happened, my lord. The rents are fixed by way of a standard table of rent, my lord. And that there is a detailed mechanism provided.
That we have dealt with.
My lord. So now what happened, my lord?
Standard table,
My lord.
area-wise, region-wise.
My lord.
Now, if it's a particular property,
My lord.
it might come under standard rent, say, it might come under 2 zones.
My lord.
A, B.
My lord.
A standard rent may be X.
My lord.
B may be, zone B may be Y.
My lord.
Or Y plus 1.
My lord.
Now, this computation,
My lord.
property-wise, has to be made by somebody on the basis of the standard table.
My lord.
We are not altering the standard table.
So, my lord, for that, my lord, the competent authority is the cantonment executive officer, my lord. And he is the person who has issued the demand notices and asking them to
Then my
submit
learned
their
friend is saying
objection.
this. Your Lordship will hear me on this. This is incorrect statement, my learned friend. Kindly comes to page 161 of the affidavit. What he's saying is contrary to his own affidavit. I'm sorry that he's making this statement, my lord. Page 161. My learned friend's affidavit. (160) and 161. The procedure is that the concurrence is obtained from the Deputy Commissioner, but it is determined by the Kindly comes to page 161.
Yes.
Although CLAR 2021 states, for determination of STR for lands in a cantonment, the concerned defence estate officer shall constitute a committee which shall consider chairman, etc. This is the present one, 2021. However, action was taken by defence estate officer for revision of STR in respect of Shillong cantonment prior to issue of 2021. Therefore, the actions taken by defence estate officer for fixing the STR rate in order in terms of the prevalent instruction. Absolutely plain and simple English, my learned friend's affidavit. Kindly rely on this affidavit and pass the relevant order.
Where is our order?
Yes. Lordship's order kindly comes to page 20. The order starts, my lord, at page 27 and the relevant part is at page 38. Page 38, where your Lordship says in the second last paragraph, the respondent authorities will consider the objection. My respectful submission is, in accordance with my learned friend's affidavit, page 161, the word authorities should be substituted by defence estate officer.
Can we say the respondent authority as nominated or designated by the Ministry of Defence, New Delhi,
Okay.
shall furnish to the
Now,
appellant?
according to the rules, is defence estate officer itself.
We will leave it to the Ministry of Defence.
But the rules say defence estate officer, my lord.
So let the Ministry
In
of
accordance
Defence,
with the Ministry of Defence, in accordance with the relevant rules, your Lordship keeps.
that will,
In accordance with the relevant rules. Very well.
your client will have nothing to say in that. It's his ministry
Yes.
will nominate an officer in accordance with the rules to make the
Very
computation.
well.
My lord,
No, what he has to say in that.
No, my lord, I'm not.
He has some interest in the matter.
No,
No, why am I objecting to this?
No, Dr. Bodhika, you please warn him. We are saying Ministry of Defence, New Delhi, and he is jumping up and saying, no, it should be somebody else. Why?
Strange.
As nominated by Minister of Defence.
Ask him to be careful and not too smart in court.
Well,
Please take down. After hearing learned counsel for the parties, we dispose of this application for clarification or modification of our judgment and order dated 3rd July 2025. By making the following change. In the last paragraph of internal page 12 of the said order, in the following manner, colon, next line, in the second line, quotation, respondent authorities, unquote, shall be substituted by authority designated or nominated by the Ministry of Defence, New Delhi, in accordance with the applicable rules, unquote. Next line. The same alteration will be made by replacing quotation respondent authorities at lines 4 and 5 of the said paragraph.
Let him finish.
Paragraph, the time stipulated for compliance or implementation
That may be extended, my lord.
of the said order
instead of 6 weeks, my lord,
shall run from today.
but may I prefer
2 months from today, my lord, that because it says 2 months. So
No, it's
6 weeks.
6 months from date, 6 weeks from date, so 6 weeks from today.
6 weeks from today, well.
My lord, may I pray for little extension, enlargement of time, my lord, because the ministry has to nominate.
Very
10 weeks time is given, my lord.
We have no difficulty.
3 months. from
3
today.
months.
Obliged.
The judgment and order dated so and so is modified to the above extent only.
Obliged.
All right. The same alteration will also will apply to line 2 of the first paragraph of internal page 13 of the order.
Grateful to my lord.
Yes.
Number 2 to 5.
Lordship, I am appearing for the respondent number 4. My lord, today is fixed for hearing of the appeal. My learned friend will start, my lord, before he starts, my lord, as an officer of the court, my lord, I think it is my solemn duty to place before your lordship whether I get the order or not. My lord, the conditions of one of the conditions of the tender, that is the, my lord, enlistment certificate of Meghalaya, condition 6 was not complied by any of the, my lord, participants in the tender process. So, my lord, prima facie, that renders, my lord, the tender process itself, my lord, infructuous, which has been very well taken into account by the Honorable Single Judge. Now, if your Lordship kindly comes to once, my Lord, page 20 of my learned's paper book, my Lord. Page 20, my Lord. My Lord, column 6, first is general terms and conditions, my Lord. Your Lordship got, my Lord, page 20.
Yes.
My Lord, column 6, all quotationer should furnish a valid registration certificate registered under Invest Meghalaya as per Meghalaya Industrial and Investment Promotion Policy 2024. My Lord, with greatest respect and utmost humility, that was not, my Lord, complied by any of the participants, including the appellant and my client. I must be fair before your Lordship. This has been taken account in the judgment of the Honorable Single Judge. Now, your Lordship.
Which page is that?
My Lord, page 20, I have showed. Now, your Lordship wants to see, my Lord, the judgment.
No, which clause you were referring to?
My Lord, 6, my Lord. I am placing page 20, your Lordship, kindly see. General terms and conditions. Your Lordship got, my Lord?
Yes.
6. 1, 2, 3, 4, 5, 6. All quotationer should furnish. My Lord, the word has been used as should, mandatory, not may. Should furnish a valid registration certificate registered under Invest Meghalaya as per Meghalaya Industrial and Investment Promotional Policy 2024. It has not been complied by any of
By your client also.
also. My client also.
You see, this is not a public interest litigation.
My Lord.
This is not the subject matter.
My Lord.
Your subject matter is that this point nobody is taking.
Yes.
Your point is whether your tender should have been accepted or is.
My Lord. And
On your application,
I'm grateful. I'm grateful.
the award of tender was set aside.
My Lord.
And your
Even after compliance of all the formalities on behalf of my client, that bank call and everything, that on the last occasion I will again place when occasion will, my Lord, rises. My Lord, my tender was cancelled and I am only the manufacturer. The other participants are not the sole manufacturer. That is the difference between my client and others.
what was the tender for? House building.
My Lord. Of the poor people.
Your point is your technical bid was ignored.
Technical bid, my Lord, was never, my Lord, opened. So far, my client is concerned. Was never, my Lord, opened to justify my client's application. He has been awarded, and when I
What
got,
is the value of the contract?
what is the value of the contract?
It's about 60 crore, man.
60.
60.
When was the award made?
It was in the month of
10 September 2024.
You have started work.
my lord. Initially, I placed some order with the suppliers, my lord, and then the judgment came, my lord, with the London Single Judge.
When the writ was filed?
My Lord, 12th we came to know, 12th of December, and 16th of December, my Lord, the writ was
December,
filed.
the rate was filed.
Just 4 days.
10th of September, the contract was,
Yes.
work order was issued.
Yes, and we came to know on 9th of December.
And it was filed then.
Yes, immediately it was filed within
The
4
court
days.
passed any order of injunction?
No,
Restraining.
your lordship, my lord, when your lordship has been pleased to, my lord, the entire tender process was, my lord, cancelled and fresh
No,
tender was
as
issued.
an interim order. You got any interim order?
My lord, yes, your lordship has been, my lord, in the appeal.
No.
Before your lordship.
Before the learned single judge.
No, learned single judge, my lord, your lordship kindly, my lord, just I am placing that part, my lord, of the order. Your lordship kindly comes to, my lord, page 212 of the paper book, para 46.
There was a stay order, my lord.
Para 46, my lord. Your lordship got, my lord. Page 212 of the paper book. That is, my lord, Writ Appeal 44 of 25. Your lordship is looking perhaps.
We are doing a 212.
Yes, I am grateful, my lord. Accordingly, for the reasons aforementioned, the entire tender process pursuant to the NIQ dated 10/9/24 is hereby set aside. The consequential work orders issued to the respondents number 4 and 5, therefore, shall accordingly also stand cancelled. However, keeping in mind,
What is the reason?
my lord, reason of cancellation of this, yes, that has been, my lord, if your lordship kindly comes to para 32 onwards, I am placing, my lord, that is page 198 of the same impugned order. Page para 32, page 198. Your lordship got, my lord. The above noted requirements, the para starts. The above noted and your lordship subject to correction,
Technical consideration is that they don't have any work experience.
well, we have better experience. We have better experience because we are only the sole manufacturer. Your Lordship, kindly appreciate one thing. The tender was to promote by law roof for the poor peoples at large. Now, as because we are the only, my client is the only manufacturing, sole manufacturer.
No,
They are not the sole manufacturer.
Learned judge has said only the registration certificate is produced.
Apart from that, my lord, if your lordship kindly have a look at para 34, my lord, the onwards, may I place page 200? Page 200. Para 34. The decision was not of the tender committee, but had been on a decision of the minister in charge. If your lordship kindly escape 7-8 lines, para 34, my lord, the line started that the allocation of work was not on the decision of the tender committee, but had been made on a decision of the minister in charge, as it is revealed in para 10 of the affidavit filed by the state respondents. In the said affidavit, the state respondents, in spite of the stipulation of the amended NIQ as regard this requirement, have stated that the function of the tender committee is to approve the bidders. The decision with regard to the allotment of the supply order lies with the head of the department, and since the head of the department is the minister, approval has to be sought from such minister before the supply order is to be issued. This awardment, therefore, in view of this court, flies in the face of clause A of the financial bid, whereby the tender committee was to be the final authority in case of the two bidders being equal. As such, the decision to allot 75% of the supply order to the respondent number 5, Power Roofing, and 25% to the respondent number 4, that is Meghalaya Roofing, does not appear to have been made on any rational basis, considering the fact that both the bids were at par. This also, in opinion of the court, is a decision taken without jurisdiction, notwithstanding the fact that the respondent number 4 has already accepted the supply order initially under protest, has now preferred a writ petition against the unequal allocation. And here I am pausing here for a moment.
No, come to paragraph 44.
44, I am coming, my lord. I am coming. Yes, page 212. As per the above noted circular, submission of a tender paper does not fall under trade as per the Act. But if a non-tribal becomes a successful bidder, a trading license issued from the concerned district council before any work involving trade is issued is necessary. My lord, here, what fell from your lordship, my lord, with greatest respect, I am submitting in the affidavit in opposition, my lord, the state has submitted this dispute, which has been raised by my client, squarely comes under a civil forum. As your lordship has vast experience, I have also judgments right from AIR 1981 Supreme Court. It is coming under the purview of state as Article 12 of the Constitution of India. So this plea of the state does not hold good, my lord. They want to shield, my lord, the appellant, and my lord, they want to throw away initially, my lord, my clients, who are also...
No, but we have not still been able to understand what is the technical deficiency, lack of work experience in Meghalaya.
As far as my client is concerned, as fails from your lordship, only 2 points were taken, my lord, against my client. One is that the amount which has been deposited, the tender committee says that...
No, on what ground you succeeded? You succeeded in the date.
My lord, tender has not been opened.
My friend, with due respect, my lord.
I have applied.
I'll place very few
I have
facts.
applied, but it was not considered on 2 grounds. The tender committee has not considered on 2 grounds. Number 1 is the call deposit, which is not correct. That has been considered by the Honorable Single Judge in the earlier writ petition. As a consequential factor, the bank has already sent a letter and stated that, my lord, it falls under call deposit. And the second is that I don't possess a certificate of registered license so far the state of Meghalaya is concerned. That also has taken, my lord, in the earlier writ petition. that it is a consequential factor. If I am successful, then the question will crop up.
So your cause of action is your eligibility.
Yes,
But then your tender was not considered, it was awarded to him.
yes.
So now you cannot, without any locus, your tender has not even been considered. You cannot say that his should be cancelled.
My tender has not been opened, Your Lordship. Kindly appreciate. That is pending.
Your cause of action should be restricted to that.
Yes, and my lord, restricted, my lord. So far, if the tender has been allotted to my learned friend, is malafide, is biased.
No, that
My lord-
that locus you don't have.
My lord, with greatest respect, my lord, I have judgments of the Honorable Supreme Court, my lord.
Whatever Supreme Court may be.
My lord,
You file a public interest litigation, it is all right. But you have no locus itself. If you were a candidate, a bidder,
Yes.
then you have locus that why my bid was not accepted.
I am a bidder.
But you have not reached the bidding stage.
My
Your
lord-
bid has not been considered. At the threshold, you have been stopped.
My lord,
Now, your cause of action should be restricted to my bid ought to have been considered.
My lord, that is the reason, my lord, the writ petition was filed. And my lord, if your lordship kindly appreciate, if I may,
No,
able to, my lord,
no, the thrust of the judgment is why he should be cancelled.
the crux of the judgment, with greatest respect, your lordship, is that retender has been issued.
On what ground?
That is for fair, my lord, the maintaining the tender process, which
No, but
has not been maintained.
where is
here.
the finding that your bid should have been accepted? Your bid should have been considered. Acceptance comes second stage.
No, that is not the point.
Then-
My lord, here what happened, my lord, my lord, I have not filed the appeal. Your lordship, kindly appreciate one thing. My lord, the appellant has filed the appeal. On the ground, there is also not the order that his bid will not be cancelled. The order was passed by the Honorable Single Judge that considering all the aspects of the matter, it is not a fair approach which has been taken by
Mr.
the
Mitro, prima facie, we are telling you, you get ready on this point and come tomorrow.
Very well.
You are here today,
Yes,
you come tomorrow.
Very well.
That your cause of action should have been limited to
my lord.
your bid being taken on record.
My lord.
Then after comes consideration, then after comes award of the contract. Now yours was not even taken on record and his contract was awarded. Therefore, you cannot jump your cause of action. Your cause of action is consideration of your bid. And whether the matter should be remanded to the learned single judge to consider that issue only. Consequential reliefs are there. If you succeed, still the contract would be set aside and there would be a fresh tender.
Yes. No, fresh tender, my lord, that is the order
No,
of...
but not jumping the queue.
My lord, that is the order, with great respect, that is the order of the Honorable Single Judge, fresh tender. Your lordship, kindly see, my lord, the ordering portion.
If you were ineligible even to be considered, then your writ is liable to be dismissed,
My lord,
having no locus.
my lord, so
But
far,
if you are found to be eligible but wrongly kept out, then you have a cause of action. That issue was not gone into. You were allowed to jump the cause of action and attack his award of tender on the ground of his technical deficiency, whatever.
my lord,
That at this point of time, at this stage, you don't have the locus. In a public interest litigation, maybe.
my lord, so far,
Then there will be thousands of writ petitions before the
my lord,
court.
so far, my lord, what failed from your lordship, my lord, I try to reply, my lord, with greatest respect, that if your lordship kindly see, my lord, so far the...
Mr. Mittal, you have understood the point.
Yes, I
Please come
understand.
tomorrow.
Very well,
Yes.
tomorrow.
very well.
List this appeal for further hearing.
যশোয়া বলছে
Tomorrow.
বাবা, কাল আসতে আমি কাল করে দেবো।
Put the date. We have heard Mr. Mitro extensively. Stop. List this appeal for further hearing tomorrow.
My lord. Only one, my lord, indulgence can I pray before your lordship? If your lordship kindly, lord, what will be the fate of the matter? That is up to your lordships, my lord. My lord, call for the, my lord, record so far the tenders are concerned, which has also been submitted by my client, so that, my lord, the actual picture can be, my lord, looked into by your lordship, my lord. Whether I am eligible or not, my lord, that point has not
You
been...
make your argument. By tomorrow, the records cannot come.
Well,
We will see tomorrow.
my lord, if your lordship kindly record my one-line submission, my lord, this I have submitted at least before your lordship, my lord. So far records are concerned, my lord, if your lordship. Well, I understand tomorrow it will not come, but if your lordship kindly record, my lord, because
No, if we direct production of the records, we will record your submission and direct production.
Well, and the-
Now it is no
my lord, I have
no use.
I understand.
Number 6 to 20.
This matter, my lord, I was requesting for next week, my lord. This 6 to 17. This is work relating to work charge establishment, my lord. On 4th, I was requesting, my lord, today, because that excise matter is listed for.
All right. By consent of learned counsel for the parties, list these appeals on make it third, Mr. Advocate.
Your lordship, on
You have some difficulty.
on 2nd, I may have to argue in presidential reference in Supreme Court. So 3rd, I will be traveling back
All
to.
right. Fourth.
21 to 23.
May it please, Lord. Lord, I have covered almost all points, my Lord. Only three things are left, according to me, my Lord. My power under the Act to amend the regulation and create central bonded warehouse. Those provisions I have shown, my Lord. I have to show only one provision which was left out, that is Section 36, my Lord. Kindly come to the excise manual, my Lord, Section 36. Page 27, my Lord. Section 36, my Lord. Page 27, my Lord. And the provision is Section 36, subsection 2, my Lord, at page 27, my Lord. The state government, power of state government to make rules, my Lord. The state government may make rules for the purpose of carrying out the provisions of this Act or any other law for time being in force relating to the excise revenue. 2. In particular and without prejudice to the generality of the foregoing provision, state government may make rules, my Lord, and kindly come to Rule D and E, my Lord. Only page 28, my Lord. D and E, my Lord. D says, my Lord, regulating the import, export, transport or possession of any intoxicant, my Lord. So D, in exercise of power conferred under 36 2 subsection D, my Lord, the rules have been amended, my Lord. And E also, my Lord, kindly mark this, regulating the manufacture, supply, storage or sale of any intoxicant. So by way of powers vested in the state government under section 36 2 D and E, my Lord.
Also F we have marked.
F, yes, my Lord. F I have also, my Lord. And then your Lordship will see F is specifically for warehouses, my Lord. Regulating the deposit of intoxicant in warehouses and removal of such article from warehouses, my Lord. Your Lordship may mark warehouses, distilleries or breweries, my Lord. So the Act confers ample power on the state government, my Lord, to amend the rules for carrying out the purpose of the Act, and those powers are clearly delineated in section 36 2 D, E, F, and even, my Lord, H will also, in my humble submission, apply, my Lord. H also says prescribing the procedure to be followed and the matters to be ascertained before any license for such sale is granted in any local area. And lastly, my lord, L also, my lord, if your lordship will notice, K, prescribing the restrictions under the conditions. Prescribing the restrictions under and the conditions on which any license, permit or pass may be granted, my lord. So these are the powers which I have, my lord. So I have completed the part with respect to the law, my lord. Now, second, one document, my lord, because they have argued that it is causing lot of prejudice to them because of creation of central bonded warehouse. But their case throughout, even to the central government representation, is that who will bear the cost of creation of central bonded warehouse. That admission is reflected, my lord, in their own document, and kindly see one page only, my lord, that page 64. Of the paper book, my lord, where the admission is very clear. If your lordship will kindly come to the representation which they gave against the page 65, my lord, against the state government, against the creation of central bonded warehouse. And in that very letter, my lord, first letter of 13 May 2021, their entire case was that this burden has to be borne by the consumer, not by them. That's the only financial constraint they have raised. Your lordship may kindly see the letter at
Yes,
page.
they said the state should bear it.
No, consumer. If your lordship will see page 65, the representation by the petitioner to the state government. This is the precursor to the writ petition, my lord. Page 65. And they enumerates the benefits of central bonded warehouse in this paragraph, my lord, in this representation at page 65, last paragraph, one paragraph only, my lord, page 65. There is no clarity as to the service that CBW will provide and benefits it will bring to the suppliers, to the government or the consumers. It is only fair that beneficiaries of the yet indeterminate services should pay for such services. To amplify, if the creation of CBW is for ease of government control on supplies.
So you come to page 66,
Yes, my lord. Yes, my lord.
second bullet.
Okay, yes, creation of monopoly
No,
and
second-
a private one.
Second bullet.
Oh, sorry, second. Allow the additional cost of introduction of CBW to be absorbed by the government or to be passed on to the consumer by way of an increase in end consumer prices. So the issue is not, my lord, that we have, who will bear the extra cost. And London Senior Counsel has covered that economic aspect in his argument. So therefore, my lord, and if I simply place, my lord, first paragraph also, my lord, of the last paragraph, last three lines of the previous page, my lord, to amplify, if the creation of CBW is for ease of government control on supplies, rightfully the margin should come from the government revenues. Alternately, if the introduction of a CW is for supply chain is to enhance the consumer confidence in the genuineness of the product being sold, then it is only fair that consumers should pay for the cost by this way of an increase in the consumer price and that they pay. So the only issue in my humble submission is who should bear the extra cost, not the legality, not the power, not the competence of the government, my lord. And lastly, my lord, if your lordship will see the conditions which we have imposed on the central bonded warehouse, those conditions will also amplify and will show that there are sufficient checks which have been imposed, my lord. Only 3 clauses of the conditions I wish to place, my lord, page 60, my lord, of the paper book. Your lordship may kindly see the license conditions at page 60. And then my argument is over, my lord. Page 60 and condition number, your lordship, will come at page 61, Roman 8. That he shall keep regular and accurate daily accounts in such form and as may be prescribed by Excise Commissioner of all foreign liquor and spirits received into and issued from the warehouse. So entire accounts have to be maintained. 10, my lord, he shall permit any excise officer of or above the rank of Inspector of Excise to have at all hours free access to the central bonded warehouse, places appertaining thereto, and on demand by any such officer he shall produce for inspection his account of deposits and issues of foreign liquor and spirits. 11, my lord, that when required by any excise officer of above the rank of inspector, he shall assist him by sufficient number of employees in taking accounts of his stock and for gauging foreign liquor and spirits on receipt and at the time of issue. 12. He shall permit any excise officer above the rank of inspector to take sample of any foreign liquor or spirit stored and so and so. And lastly, 15, my lord, the licensee shall be bound to maintain such minimum stock of foreign liquor and spirit in the central bonded warehouse as may from time to time be fixed by excise. So these are enough checks and balances, my lord, on the central bonded warehouse to ensure that the operations of central bonded warehouse is carried in fair and transparent manner. I am grateful, my lord. That is all I have to submit in respect.
Thank you very much. Thank you. Yes, Dr. Wazir.
I'll take 10 or 15 minutes. My lord.
Yes, sir.
But
Which
these
is
are some of the
point number
documents.
3?
These are some documents taken out from the records only, my lord.
That is the central bonded warehouse.
My lord. So, my lord, I'm as far as the power under the Central Excise Act and rules, my lord, I'm adopting the submissions of Mr. Banerjee and the learned advocate general, my lord. Only a few additional points, my lord. I'll only take 10 or 15 minutes, my lord. My lord, the first aspect is that license was granted to us on 26/3/21, my lord. I've pointed out in this, my lord. And we started operation with effect from 26/7/21.
License granted on
26/3/21 on the first paragraph of my notes, my lord.
Yes.
Lordship kindly sees, my lord. And we started operations since 26/7/21. So it's more than 4 years, my lord, now.
started 26.
7/21. So now, my lord, we are over 4 years in operation, and till date, because the entire writ petition is founded on apprehensions, my lord, that CBW, being one entity, my lord, they'll be able to manipulate downstream market, upstream market, they'll be able to manipulate the prices. In last 4 years, my lord, there has not been a single complaint either from Mr. Saha's client or Mr. Paul's client, my lord, till today, in last 4+ years of operation, that there was any attempt at manipulation.
This is in a lighter vein.
My
This
lord.
notification is 2020. This
Yes, ma'am.
notification. License granted 26/3/21.
My lord,
Started 26/7/21.
my lord.
We were at that time in the thick of COVID. So the thing was they'll sit at home and drink. Or what? What was the policy?
Well, because the process, my lord, it was.
They'll sit at home and drink. Yes, next.
Now, my lord, I'll take your lordship to page 5 of this compilation, my lord.
Yes.
My lord, kindly see page 5, my lord. My lord, every manufacturer has to register the brand in Meghalaya, my lord. Every manufacturer has to register the brand. So, page 5 is one of those examples, specimen, my lord. This is to Pernod Ricardo India Private Limited, who is one of the petitioners, my lord, a member of the petitioner company. They have registered their brand, and this is by the Commissioner of Excise Meghalaya. With reference to the letter so and so, you are hereby informed that registration of the following brands is approved for sale in Meghalaya. So in Meghalaya, only those brands can be sold, my lord, which are registered with the Office of Commissioner of Excise. Page 6 is another example of similar registration to a different company, my lord.
Yes.
Page 7 is also another example. Now, if your lordship kindly comes to page 9, my lord. This is in my humble submission, this is a little important, my lord. My lord, this is an indent issued by the Commissioner of Excise to a bonded warehouse, my lord. My lord, what happens here? A bonded warehouse, when they require certain quantity of stock of a particular brand, my lord, they don't approach us, my lord. They first go to the office of Commissioner of Excise. Page 9 I was referring to, my lord, in my compilation. The lordship will say this is import permit number so and so, dated is given. It says, my lord, Messrs. Valentine Bonded Warehouse, Ferndale Compound so and so are hereby permitted to import under bond number so and so, so and so, so and so, from Messrs. Umpolio Central Bonded Warehouse so and so. So bonded warehouse, they don't come to us, my lord, directly. They go to office of the Commissioner of Excise. They pay their duty there, my lord. And on the basis of that, Commissioner of Excise issues an indent to us, my lord. An indent mentions, my lord, the brand, the quantity, the size of bottle, 350 ml, 700 ml, how many cases of liquor has to be supplied, my lord. And at the bottom, your lordship will see copy mark 2 at serial number 2. At serial number 2, copy mark 2, my lord, you will see excise officer in charge of Umpolio Central Bonded Warehouse. There is an excise inspector stationed at CBW, my lord. And the bonded warehouse will come to us with this indent, my lord. And in the presence of the inspector of excise, we have to supply these very brands, these very quantity. We cannot change this brand or this quantity, my lord. And this is done under the supervision of inspector of excise, who is stationed permanently at the CBW, my lord. So, my lord, what I am trying to submit, my lord, everything is structured, my lord. Bonded warehouse doesn't come to us with an empty bag, my lord. Okay, give me this, or so that we can manipulate them, my lord. They come with an indent issued by the Commissioner of Excise. So it is absolutely impossible for us, my lord, to tell the bonded warehouse that no, instead of Glenfiddich you have asked, you please take this some other brand. Because inspector of excise is monitoring everything, my lord. And till date, Mr. Paul's client, who are the bonded warehouses, my lord, till date, for last 4+ years of operation, they have not been able to furnish a single complaint, my lord, that we have dishonored any of this indent, my lord. My lord, pages 10, 11, 12 are similar indents, my lord. So this is how the system works, my lord. It is not in the hand of CBW to tell any bonded warehouse that you please don't take this brand, you take some other brand. But there is a very formal, structured mechanism for this, my lord. Now, my lord, coming to page 13, my lord, Mr. Banerjee also already submitted on this aspect, my lord. The rates are notified by the Commissioner of Excise, my lord. The retail prices periodically. Now, my lord, page 19, your lordship kindly sees, my lord. This is the state's affidavit I have annexed here. How the revenue has grown over the years, my lord, since the introduction of CBW. Page 19, my lord. And only one more document I wanted to place, my lord. Page 22, my lord. How the sales have increased, my lord. Mr. Banerjee also produced details of 5 brands, my lord. I've compiled a chart of some more brands. At page 22, lordship will see all brands, my lord. And lordship will kindly note, my lord, these are all members of the petitioner, Mr. Sahas Klein, my lord. Imperial Blue at serial number 1, my lord. This is a ISWAI member, is a Pernod Ricardo. Their sales has grown up from 66,000 to 4,68,000, my lord. Similarly, Royal Stag, this is also a member of ISWAI, my lord. Their sales have gone up from 3 lakh to 6 lakh. So just to indicate, my lord, how the sales have gone up, my lord, during the period of operation of the CBW since its inception in last 5 years, my lord.
Yes.
And only one judgment I wanted to place, my lord, that because the entire writ petition is set up on apprehensions, my lord. Writ petition was filed in 2021, my lord. We are in 2025 now, and we have the data available now. 21, there were apprehensions, my lord, and the data available, which I placed before lordship, they ward off all those apprehensions, my lord, of manipulation of price or manipulation of brands of anything, my lord. But only one judgment, my lord. This is it starts at page 23, my lord. This is judgment of Collector of Customs versus Nathela Sampatu. I'll just refer to para 34, my lord. This is the last submission, my lord. At page 47, my lord. At page 47, para 34, my lord. I'll just read last 5 lines from the bottom of this.
What is the citation?
Citation is 1962, AIR 1962, SC 316.
SC 31.
AIR 1962, SC 316. That will lots will find at page 23, the citation.
Page? Para?
Para 34. But I'll just read 5 lines of. It starts with this court has held in numerous rulings. Lordship's got. It is about 13th line from the beginning. Well, this court has held. Lordship, this court has held in numerous rulings to which it is unnecessary to refer that the possibility of the abuse of the powers under the provisions contained in any statute is no ground for declaring the provisions to be unreasonable or void. Commenting on a passage in the judgment of the court in appeal in Northern Ireland, so and so, then I may skip my lord. Then it again says the possibility of abuse of a statute otherwise valid does not impart to it an element of invalidity. The converse must also follow that a statute which is otherwise invalid as being unreasonable cannot be saved by its being administered in an unreasonable manner. The constitutional validity of the statute would have to be determined on the basis of its provisions and on the ambit of its operation as reasonably construed.
All right.
So, my lord, with this, I'll conclude. My lord.
Mr. Singh, tomorrow.
Please, ma'am. My lord, only one suggestion. My lord, my writ does not have, my lord, the other side as party respondent. The writ is only between us and the state.
That is all.
The only question there is whether the second CBW can be opened or not. So if it can be after this matter, because my lord, on the last date of hearing also, I was making a request that my would be subservient to the outcome of this writ petition. if my lords are to hold anything that the whole notification goes, my lord, then my writ does not even survive at all. I may not even have to
What
order.
my friend is saying, my lord, that the issue in the first two writ petition is whether the government has power to create central bonded warehouse or not. If your lordship holds that government has no power, then we will have no right to even create second bonded warehouse. So that is why my friend says that after the matter is heard and decided, so there will be.
See, as of now, the central bonded warehouse remains.
Yes, ma'am.
There is a writ by an organization challenging its creation.
Yes, madam.
Now, there is also a policy of the government or a move by the government
Yes, ma'am.
to create the second central, for which tender has been floated
Yes,
and offers received but kept in abeyance. So there is no problem in hearing.
Yes, madam.
No, my suggestion was only this much, that my writ be heard after this matter, because otherwise I may not even have to argue altogether.
You don't have.
And the other side is not even respondent. So right now what is happening is my matter would be heard in between this matter, and Mr. Saha would respond to everything altogether, even though he's not a party.
You consider yourself as subordinate legislation.
Yes,
And the central bonded warehouse as the main legislation. If the main falls, the subordinate does not survive.
Very well.
Got it?
I'm so grateful.
Your
There is no head, there is no headache.
no
There
headache,
has to be a head and then the headache
and
can go away. or
that will
remain
be
in the person.
dismissed. But we will observe if that is the situation, that we have not gone into the merits of the matter. That will be kept open.
yes.
So grateful.
Only one thing.
For whom? Yes, in the event Mr. Singh finishes, and we request him to finish, Mr. Saha will begin and positively
Grateful.
complete by Friday.
Grateful.
Grateful.
And to abridge his submissions in reply to that extent. All the notes will come in by Friday so that judgment is
My
made.
Lord, before your Lordship, at the 26th August
Grateful.
affidavit we had filed, Lordship may kindly record that it has been filed. The one with the figures I've given,
Yes.
Yesterday, it was
yesterday's file. So, Lordship kindly records
in the order.
in the order that this affidavit has been filed. Your Lordship has given us leave to
Yes,
file
we are taking on record an
26th
affidavit,
August affidavit.
by the state affirmed on 26th August 2025. What is that? Showing the sales.
Yes,
Showing the
yes.
Increase in sales.
Showing the sales. Which your Lordship had said should be in an affidavit form and not on a piece of paper. Right?
No, but then
Sale of liquor.
Sale of liquor.
sale or revenue earned by the government.
No,
Turnover.
Sale. Actual.
Sale.
All right.
Number of cases sold. Your Lordship.
All right.
I'm grateful.
Stating the
Actual sales of the various brands of the petitioner associate.
the turnover from sale of diverse brands of liquor from the date of coming into effect of the rules till date.
Man. Obliged.
Copies of the said affidavit
I've already been supplied.
have been served on all other appearing parties. Also, to do complete justice in this appeal, we shall rely on that affidavit as one introduced under Order 41, Rule 27 of the Civil Procedure Code.
Obliged.
Listed for hearing tomorrow.